Marc Thouvenin will be our first speaker. He's a professor of international and European law at the University Paris-Est Nanterre, La Défense, and gives an annual lecture on competition law here in Bucharest for our students of the Collège Juridique Franco-Roumain. He is also the director of the Centre de droit international de Nanterre and of Master 2 International and European Law, and for the Collège International de Droit. His doctoral thesis was devoted to the EU merger control, and he wrote many articles in European competition law. He is also a practitioner before the International Court of Justice, the European Court of Justice, and national courts. Before national courts, his practice is mainly concentrated on competition law disputes. So, dear professor, the floor is yours.
Thank you so much. I had not the chance to plead before you, but maybe next time it will happen. Ladies and gentlemen, please let me first thank the organizers of this nice and useful event in a marvelous place, a little cold though, and particularly the sponsors and Adriana Almassan for the kind invitation. I've chosen to present today a topic which is not really familiar to competition lawyers, which is focused on Regulation Brussels I. Regulation Brussels I is a matter for private international lawyers more than for antitrust lawyers. It says basically which court you should bring your actions before in any kind of case in civil and, in civil and commercial matters mainly. So normally international private lawyers and competition lawyers are quite different persons and do not attend the same conferences, but today they have to meet because our topic is the application of European antitrust law by national judges. So we have a basic question, which is the following: which national judge is competent for antitrust civil matters? In a green paper dated of December 2005 on damage actions for breach of the European competition antitrust rules, the European Commission synthesized the rules in the following. Talking about defendants in antitrust case, it wrote the following: such defendants can either be sued in the courts of the state where they are domiciled, or, at the choice of the claimant, in the courts of the state where the harmful event occurred. The place where the harmful event occurred can be either A, the place where the event given rise to the damage occurred, or B, the place where the damage itself occurred, at the choice of the claimants. Articles 6, 27, and 28 of the regulation allows coordination of different but linked actions. Now, it is important to precise first that this position is not completely right as a matter of positive law because it omits Article 23, on which I will revert later. Article 23 of the regulation Brussels I. But this put apart, one could ask the following question: is this rule that is reminded by the Commission a good solution? Even if no one seems to have doubts about it, this is debatable. To explain why, I will first develop some critics on about the liberty left to the claimant to choose the jurisdiction before which to lodge its claim, and to this effect I will discuss Regulation Brussels I, leaving aside for the moment Article 23. Second, I will show that the legal position is in reality not the one described by the Commission, on the phrase I have quoted, because of Article 23, on which we will have some discussion also. So let us first draw some critics of the forum shopping authorized by Regulation Brussels I. Now, there is no doubt that Regulation Brussels I applies to antitrust cases. Indeed, according to Article 1 of this regulation lays down rules governing the jurisdiction of courts in civil and commercial matters, which of course include antitrust cases. And this has been reminded 2 days ago by a decision reminded by the president of the panel in the Lithuanian Airlines case. And it's very clear, the first answer of the court is that obviously a claim for damages for antitrust breaches are covered by this regulation. This regulation leaves a possibility for the complainant to choose between different jurisdictions. The complainant can indeed opt for the jurisdiction of the defendant. In this regard, Article 2, paragraph 1 puts the general principles that, I quote, subject to this regulation, persons domiciled in a member state shall, whatever the nationality, be sued in the courts of that member state. But this is only a basic principle. In effect, Article 5 authorizes the plaintiff to opt for other courts. It states the following: a person domiciled in a member state may, in another member state, be sued, 1, in matters relating to a contract in the courts for the place of performance of the obligation in question, 3, in matters relating to tort, delict, or quasi-delict, in the courts for the place where the harmful event occurred or may occur. So, why such a choice? Why the complainant has such a choice? According to the European Court in Bayer versus Mines de Potasse d'Alsace, I quote, this freedom of choice was introduced having regard to the existence in certain clearly defined situations of a particularly close connecting factor between a dispute and the court which may be called upon to hear the case, with a view to the efficacious conduct of the proceedings. It sounds right. I mean, it's a very good rationale, I think, but it is right generally, not necessarily when it comes to be applied to antitrust matters. Indeed, this rule and this rationale has been adopted and mentioned in Europe at the moment where antitrust private litigations were virtually non-existent. Therefore, one question that could be put, and that was not addressed when the rule was established, is whether this rule is satisfactory concerning antitrust cases. In my view, this is debatable, and my critics relies on 3 arguments. First, it is not common ground for private international rules validating choice of jurisdiction to be applicable to antitrust cases. For example, the Hague Convention on Choice of Court Agreements, concluded in 2005, explicitly excludes antitrust matters from its scopes of application. The reason for such exclusion in this convention is that it has been considered by the signatories that private litigants should not have the right to dispose of the matter for themselves insofar as antitrust involves the public interest. This reasoning could fit in Europe, as European competition law is predominantly regulatory law, even for private damages claims. Second, Brussels I's regulation approach is to put clearly a principle, namely that the competent court is the one of the member state where the wrongdoer is located. And it puts an exception: the competent court is the one of the place of performance of the obligation or the place where the harmful event occurred. a principle and an exception. And this position has been confirmed by the court, which said that Article 5 is an exception that should be interpreted restrictively in Dumais France versus Hessische Landesbank in 1990. By contrast, we could think that the principle should be that the competent court is the court having jurisdiction on the affected market on which the complainant is active. Indeed, the object of competition law in Europe is to protect the openness and efficiency of competitive markets, and the action for damages is considered as nothing else than a reinforcement of this protection. This is so much true that even in the United States you have something like treble damages that are attached to violations to antitrust law, because antitrust laws are supposed to be pursuing a regulatory aim. It seems, therefore, not unreasonable to think that actions for damages should be located before the courts of the market that is affected, in the same manner as it is the national authorities of each member state that are competent to address anti-competitive behaviors located on their national markets. And by the way, this solution would be completely in line with Regulation Rome II. Regulation Rome II, according to which the law, we don't talk about the courts, but the law applicable to non-contractual obligations arising out of a restriction of competition shall be the law of the country where the market is or is likely to be affected. Third, the Brussels I approach may lead to incoherent legal decisions on the very same topic. Let us take the example of a company located in France, which claims it has suffered in France from an abuse of a dominant position by a company active on the European market, but located in another European country than France. The victim, in this particular case, can lodge at the same time two claims before two different authorities in charge of applying the European competition law. Before the competitive authority of France, the Autorité de la Concurrence, and before the court of the state in which the defendant has its seat. It is possible in such a case that one of these two authorities decides finally that an abuse of dominant position occurred, while the other could hold that this is not the case. And in such a case, there would be, well, difficulties to reconcile the two positions. Indeed, in the proposition of directive, very recent on, it's a very long title, on certain rules governing actions for damages under national law for infringements of the competition law provisions of the member states and of the European Union. So it's a long title. For a thesis, it would not be good, but it's very clear on what it's talking about. In this proposal of directive, it is clearly mentioned that a final decision of a national competition authority or a review court is deemed to be irrefutably established for the purpose of an action for damages brought before their national courts. But by contrast, the same final decision will only be prima facie evidence in a case brought before another court of another state. So that means that there can be a discrepancy between, finally, the two decisions of the administrative authority on the one hand and the jurisdiction on the other hand, the court on the other hand, on the same topic. Certainly, a national jurisdiction could refer to the European Court for preliminary ruling in order to secure its position that European competition law has been infringed or not. Well, but the court is not supposed to deal with facts. It's supposed to deal with the law. So even in this case, I'm not sure the answer would be completely clear. And moreover, relying it's early for me too, relying on this solution would be like accepting the failure of the decentralization movement dynamic of the implementation of the European competition law. Now, those are some arguments. It seems clear that these arguments did not convince, until now, to rethink the choice of law doctrine in antitrust matters. This is still the law. But there is another precision to bring, which is related to Article 23 of Regulation Brussels I. And the question is, does Article 23 apply to antitrust matters? Now, Article 23 is very interesting to read because it reads as follows. If the parties, one or more of whom is domiciled in a member state, have agreed that a court or the courts of a member state are to have jurisdiction to settle any disputes which have arising or which may arise in connection with a particular legal relationship, that court or those courts shall have jurisdiction. Such jurisdiction shall be exclusive unless the parties have agreed otherwise. Now, this provision is even more liberal as for the choice of court for the parties to a dispute than what we've seen before, even more liberal. This is a provision that permits parties to a contract to designate a court, well, whatever court they want to deal with their disputes. Now, as can be seen, this provision covers disputes which have arisen or which may arise in connection with a particular legal relationship. It's not so clear in my view what it means, but as the regulation applies to antitrust matters, this provision could also apply to antitrust questions. Let us see the position in this regard concerning Article 101, and then we'll see about the position about Article 102. Now, I think that a situation where you have a contract which have some link with an antitrust dispute, I think that such a situation could occur very easily in the context of Article 101 dispute. It is surely the case in the context of vertical relations between a seller and a reseller. These relations are normally established on the basis of a contract, and antitrust disputes can arise if the contract contains provisions that are in breach with Article 101 of the treaty. Now, if in the contract there is a choice of court provision, this choice of court provision should apply to the antitrust dispute. But here again, let me put the same question. Is this solution derived from private international law approach, which do not take account of the specificity of antitrust? Is this solution a good solution? I'm not sure. Once again, first, antitrust matters should not be at the disposal of the parties. Parties' autonomy is a very good thing, but when it comes to antitrust, what does it mean? Second, it should be reminded that according to the court in Bayer versus Mines de Potasse d'Alsace, if a choice of jurisdiction is recognized to complainants by Article 5, we quoted some minutes before, it is in regard of a particularly close connecting factor between a dispute and the court, which may be called upon to hear it, with a view to the efficacious conduct of the proceedings. You remember this quotation. By contrast, here, there is absolutely no such justification concerning Article 23. Obviously, under Article 23, the choice of court is completely discretionary, so that any court, even one without any connection at all with the case at stake, could be chosen. This is confirmed by the court in Castelletti in 1999. In this case, the question was put whether it was necessary for the party to a court to choose it was necessary for the parties to choose a court having some link to the case, and the court clearly answered that not at all. There is no such requirement in order to apply Article 23. If this is acceptable generally, I'm sure it's acceptable generally in litigations of a civil matter or commercial matter, this is maybe not for matters involving the public interest, which is a case concerning antitrust. And third, and here again, this could lead to incoherent legal decisions. Now, let us turn to Article 102. I'm sorry, I have to go fast. Here, the interesting question is put on the screen. Can a violation of Article 102, well, an abuse of a dominant position, can such a claim be brought by a party in contractual relationship with another? And in this case, should it be governed by the choice of court provision of this contract? A priori, one can assume that an abuse of dominant position is a unilateral conduct that is not supposed to be covered by a contractual prohibition existing between the wrongdoer and the victim. In short, it would be quite rare to find situations where an abuse of dominant position is in itself a breach of a contract. What is possible is that a contract is the result of an abuse of dominant position, but it will not be a breach of this contract. But this observation is completely irrelevant here. For Article 23 to apply, the dispute must only be in connection with a legal relationship. Therefore, a non-contractual dispute can be covered by a choice of court provision to the extent that this dispute is in connection with a contractual relationship, or more generally, a legal relationship, which is not so clear to my mind. Indeed, in connection is a very broad notion. It suggests that if there is a contract between two parties, and if there is a choice of court provision in this contract, an action for damages for abuse of a dominant position between these parties can easily be covered by this provision, even if the claim is of a purely delictual nature. The only condition is the existence of a connection between the dispute and the contract. So, as can be seen, the Article 23 of Brussels I gives large opportunities for a choice of court provision to apply in antitrust cases. And I am not sure it's a good legal situation for the reason already explained, but this is the current legal trend. But of course, Article 23 only opens a door for private actors to choose their national court for their dispute, including antitrust dispute, and at this point, this liberty of the private parties is to adopt, provisions to this effect. And sometimes the provisions are not so clear. And so the lawyer should be, I think, aware that the provision could be clear. I have illustration to finish my speech. First illustration, it's a very recent illustration, a decision of the Cour d'appel de Paris of last April, and it considered that a very not clear choice of court provision was covering a claim for damages related to an abuse of a dominant position. So in this case, the situation was concerning a seller-reseller contract, and the seller began to adopt a discriminating selling policy towards the reseller. And so the reseller could not sell any more the products because it was not purchased. Now, the problem was that the contract contained no obligation at all for the seller to sell. It was just a possibility. And the reseller claimed an abuse of dominant position, but the court said, well, this abuse is having its source in the contract, and so it's covered by the choice of court provision. just quoting here the provision which was written in this way. This agreement and the corresponding relationship between the parties shall be governed by and construed in accordance with the laws of the Republic of Ireland, and the parties submit to the jurisdiction of the courts of the Republic of Ireland. It's a very broad clause, and the court considered it was covering a claim for abuse of a dominant position with no link, no link with contractual obligations. Another illustration is the last one, if it turns. Yeah. It's a very known case, I think, by all of you. It's the Rothschild case, which has been dealt with by the Cour de Cassation of France in 2012. So here we have another problem of the choice of court provisions. It's the problem of the so-called asymmetrical choice of court provisions. And in this case, the clause was written in this way that the bank had the choice to lodge its claims before any court of its choice, while its partner, it was Mrs. X, the contractor, was to bring its case only before the courts of Luxembourg. So it was, there was a disequilibrium in the rights and obligations of the parties relating to the choice of court provision. And the Cour de Cassation considered that the clause was null. It was supposed to be contrary to Article 23 of Regulation Brussels 1. I'm not sure that the European Court would say the same. And I'm sorry, there is nothing more. So that means that I'm at the end of my speech. Half an hour is quick. I'm sorry, I've been a bit long. My conclusion is the following. Well, we have rules in Brussels 1. It's nice. It's good to have rules and to be able to rely on rules. This is some important to have some legal certainty about which court could be chosen. But nevertheless, and unfortunately, those rules leave a space for contradiction as well as complexity. They could have a dissuasive effect on antitrust case. Now the question is, should we change these rules? I don't know. I'll put you the question. Thank you.
Yeah, thank you indeed. We all expected that you made some de lege ferenda proposals. But you give us food for the next conference then. Thank you, Professor.